All right, let's get into it. You know, when we hear the term criminal charge, most of us probably think of some stuffy, complicated legal document. But today, I want you to think about it a little differently. Let's look at a charge as the foundational blueprint for a fair trial.
Seriously, just picture that for a second. You're facing some pretty heavy consequences, but you can't even get a straight answer on what exactly you're supposed to have done. How on earth could you prepare a defense? It's a terrifying thought, right? And it shows you exactly why this whole topic is so incredibly important.
Well, the solution to that confusing mess is the charge itself. It's designed to be the complete opposite of confusion. It's the blueprint that lays out the entire case, making sure everyone, and especially the person being accused, knows the exact design of the accusation they're up against.
Now let's get official for a moment. This isn't just some vague idea. It's written right into the law. You've got legal frameworks like the Administration of Criminal Justice Act that give us this very clear definition. This is the official, down-on-paper version of the accusation.
So, what it all boils down to is this. The charge's entire reason for being is to provide clarity. Its number one job is to tell the defendant in no uncertain terms, this is what we're accusing you of. It's really the cornerstone of fairness and the whole criminal justice process.
Now, to make sure this blueprint is actually fair and, functional, the law has set up 4 core principles. Think of them as the non-negotiable rules for drafting a charge that can be used to build a just trial.
And here they are, our 4 golden rules. We're going to break down each one. Ambiguity, duplicity, and then the 2 types of misjoiner, one for the offenses and one for the offenders. This is the framework that keeps the whole blueprint sound.
Okay, first up, the rule against ambiguity. This one is the big one, the most fundamental of them all. It means the charge has to be so precise, so clear, that the defendant doesn't even need to ask a single clarifying question. There's just no room for guesswork. But here's a super important point. Even if a charge is a little ambiguous, it doesn't automatically get thrown out, which makes understanding its different parts even more crucial.
So how does the law actually get that level of clarity? Well, it demands a checklist of essential details. Think of them as the exact measurements for the blueprint. Every single valid charge has to specify the defendant's name, the date and place of the incident, the exact offense, the person or victim it was committed against, and the section of the law that applies. If you miss even one of these, that blueprint is considered incomplete.
Our second rule is against duplicity. And it's a simple one, but it's powerful. 1 offense per count. I mean, think about it. You wouldn't put the plans for the kitchen and the bedroom on the same single page of a blueprint, right? It would be total chaos. It's the same idea here. A single count can't cover both, say, theft and assault. Each alleged crime needs its own separate, distinct entry.
But of course, the law has to be practical. So there are a few very specific exceptions. For ongoing financial crimes, like misappropriation, you can charge a total sum over a period of time. Sometimes, a specific law might just say it's okay. And if a bunch of illegal acts all happen in one single continuous transaction, like, say, accepting 3 bribes in the same handshake, they can sometimes be grouped together. But these are definitely the exceptions, not the rule. All right, on to rules 3 and 4, which are kind of 2 sides of the same coin. They both deal with misjoinder, which is just a fancy way of saying improperly joining things together. Misjoinder of offenses is when you charge one person with totally unrelated crimes. Misjoinder of offenders is when you charge multiple people for completely unrelated crimes. And our blueprint analogy makes this difference crystal clear. One is like trying to put 2 different building projects on a single plan, and the other is like listing contractors from separate, unrelated projects on the same document. In both cases, you're just creating a ton of confusion.
So, what happens when these rules are broken? What if the blueprint is flawed right from the get-go? Well, the system has checks and balances built in for this exact scenario. Let's take a look at what happens when a charge is defective.
You know, in law, timing can be everything. In most places, if you think the charge is flawed, you have to object before you enter your plea. If you plead, it's usually seen as you accepting the charge, warts and all. But some more modern legal systems have actually changed this. They let you object after you've already pleaded, and the court will hear your argument but save its decision for the very end of the trial. It's a really key procedural difference that can change the whole dynamic of the courtroom.
But what if the prosecution realizes there's a mistake and they're the ones who want to fix it? Is the whole thing ruined? Not at all.
The system is actually pretty flexible. A charge isn't set in stone. It can be amended at any point during the trial, right up until the final judgment is delivered. The blueprint can be corrected.
But hold on, changing the blueprint while you're already building is a serious deal. So to keep things fair, a very strict process has to kick in. Let's walk through it. First, the new amended charge has to be read out loud and clearly explained to the defendant. Then the defendant gets to enter a fresh plea to this new charge. In some situations, their consent might be needed again. And this is crucial. Both sides, prosecution and defense, get the chance to recall their witnesses or even call new ones to address whatever changed. Finally, it's all made official on the record. It's basically a controlled reset to make sure the trial stays fair.
Okay, so let's get into the fine print. Just like a real blueprint has those super specific technical notes for certain materials or structures, some criminal charges demand absolutely precise wording, no wiggle room.
And you can see just how precise the law can be. For a murder charge, the word murdered isn't optional. It has to be in there. For armed robbery, the phrase whilst armed is absolutely essential to the charge. And for conspiracy, you have to specify that it was a conspiracy to commit an offense to wit, and then you name the exact crime. It just goes to show you that in the architecture of the law, specific words can be the load-bearing walls.
So, after going through all these rules, exceptions, and procedures, let's just pull back for a second and ask the big question. Why does all this matter so much? Why is this blueprint so important?
The answer is really simple, but it's profound. These rules are not just lawyers nitpicking over details. They are the fundamental safeguards that protect a person's right to a fair hearing. They make sure that no one is ever forced to defend themselves against a vague, confusing, or just plain unjust accusation.
You know, a court case, ODAV versus the state, put it perfectly. The entire essence of a charge is to give notice. That's it. It's all about making sure everyone is working from the exact same unambiguous blueprint for justice.
And that leaves us with a final thought to chew on. We've seen how all these strict procedures are designed to protect the innocent and ensure fairness. But it does raise a deeper question about the balance in our justice system. When does this commitment to precise procedure act as a shield for justice, and when could it, maybe, become a barrier to finding the actual truth? It's a tension that sits right at the very heart of the law.